Just a heads up, I'm doing something in this video that some of my colleagues might get a little mad about. Why? Because I'm revealing really a huge secret for success in your Virginia workers' compensation case that I'd say most, if not all, injured workers who try to represent themselves miss, and even some who are represented by attorneys, the attorneys miss it. So I suggest in this video you pay close attention to what we got going on here. So I'm going to give you a typical situation. You're representing yourself in a workers' compensation claim, okay, in Virginia. And you've gotten hurt pretty bad at work, and you've had surgery, maybe even multiple surgeries, and you're still hurting pretty bad. You had your physical therapy, you had your diagnostic studies, all this done, and you're being followed by, let's say, an orthopedic surgeon. And let's say, just to make it simple, your doctors have got you out of work. They're holding you out of work 100%. You can't work anywhere right now. And as you approach a hearing, that's the situation, okay? But your claim has been denied. Obviously, you're heading into hearing because your claim has been denied by the insurance company for whatever reason, and now you're coming up on the hearing. Up until now, maybe you had to rely on your health insurance, or you've had emergency surgery or some other kind of surgery, and it's been hanging over you. The bills are hanging over your head. And let's say, for simplicity's sake, in this example, there's nothing wrong with the accident part of your case, okay? In other words, it's compensable, okay? In other words, everything is good to go for the accident part. For whatever reason, the insurance company is denying the claim and is making you go to hearing, okay? Everything's organized. You got all your medical records together nicely and organized the way you're supposed to have them. You go to hearing, you testify, you explain what happened, you put in your medical records. You leave the hearing, you're thinking, hey man, everything's looking good, right? They didn't even have any witnesses. The other side didn't have any witnesses contradicting your version of events that led to this accident. So a couple of months go by and you finally get the opinion and you're shocked beyond belief because the deputy commissioner who heard the case denied your claim. And in the opinion, it says you failed to carry your burden as to the evidence of medical causation and evidence of medical necessity. What in the heck does that mean? The opinion says you didn't carry something called your burden of proof, you the claimant, okay? And therefore, you're not entitled to a dime. You're not entitled to your weekly comp checks, you're not entitled to medical, not entitled to anything, okay? So, you keep reading it again and going, what happened? What did you miss? Hi, I'm Joe Miller, workers' compensation attorney in Virginia and North Carolina. And I'm here to talk today about what you need to prove insofar as the medical portion of your claim, which of course is going to impact your weekly checks. So this is a part of workers' compensation where I think a lot of lay people, people that try to handle their own cases, mess up because it's not widely publicized. I don't know where you would even find this, except maybe if you were to look online at all the graveyards of cases where people lost because they couldn't prove the medical causation part of your claim. So, or carry their burden of proof. So, let's take this apart and have a look at it. So we mentioned something a few minutes ago called burden of proof, right? So what is that? I'm sure y'all have heard that phrase before. So in American law, generally means, and this applies to regular personal injury claims also that you might bring in court as well, that the claimant or the plaintiff in a personal injury case, the person pursuing the claim has the burden of proof. In other words, to bring on sufficient evidence to prove your claim. In other words, you're the one, if you're bringing the claim, you are the one that must prove your claim. The other side can't prove it for you. Only you can bring sufficient evidence to prove the claim. Now, when it comes to the happening of an accident in workers' comp, that involves factual testimony. It's the facts. Do the facts fit the definition of what an accident means? And as we've discussed in other videos, and I'm not going to get into it too much here, just suffice it to say, in Virginia and in North Carolina, they're a little different, okay? North Carolina's got a little stricter standard than Virginia to prove an accident or an injury by accident. And that's all you need to know. If you want to watch those videos, I encourage you to do so. Assuming you can prove that part in our example that we first gave, that's assumed, okay? Then we have a second part of the workers' comp claim, which you also have to prove, which is not really factual. It's really more of an opinion, believe it or not. It's an opinion type of thing. And who does the opinion? Your treating physician, your authorized treating physician, or if it's a claim is denied, whatever physician has been doing all your work on you. That question is, very simply, were your injuries that you suffered on the job caused by your work accident? And is your medical treatment, was it necessary to treat those injuries? And is that treatment also related to the accident? Okay, pretty simply, that's the issue. And this is where a lot of folks miss out, because there are certain standards of proof that you must reach in order to prove these things. A lot of you folks out there might watch TV, maybe some of you watch Law and Order or some of these other shows, and you've probably heard a standard of proof that is mentioned in criminal cases, which is commonly referred to as reasonable doubt. Okay, means that you want to convict, the state wants to convict this guy, in Virginia, the Commonwealth wants to convict somebody. Okay, they got to prove the case against this person beyond a reasonable doubt. Okay, that is a criminal standard. Okay, for criminal cases, don't have to worry about that. Workers' comp cases are civil cases, just like a personal injury case. It is a civil case, and you do not have to reach that level. All you have to prove in a civil case is something called the preponderance of the evidence. Okay, what does that mean? Very simply, it means more likely than not. Much lower standard than beyond a reasonable doubt. More likely than not. What does that mean? What's another way of saying that? Probably is another way of saying that. Or 51%. The way that's often expressed is through these magic words. And there's a lot of magic words when it comes to this. I'll tell you that right now. And the magic words are the doctor has to say his or her opinion with a reasonable degree of medical certainty or probability. In other words, more likely than not. Okay? If they say it that way, then you're good to go. Okay? The key word is probable or probably. Okay? If your doctor says something that, you ask the doctor a question about, well, is this related to my accident? And they say possibly, or it might be, that will not suffice. Why? Because that is below the 50% standard. If the doctor says possible, if they put possibly anywhere in their opinions about whether your injuries are related, you're finished. Your claim will not survive the scrutiny of the deputy commissioner. And here's the thing that many people miss. If the records that you are putting into evidence are silent on this issue, doctor says nothing about it. It's just, he's just treating you and going on with it, which is the way most medical records are. Only a few doctors are smart enough to anticipate this and actually stick this kind of thing in their records. There are a few that will do it, but most won't. Okay? And so if you don't draw it out from the doctor, if you don't ask your doctor and put in a piece of evidence that contains their opinion about this, causation issue, you got a problem. And you might think, saying to me like, wait, Miller, I fell off a roof, I smashed my ankle, or whatever the injury was, and I had emergency surgery that day or the next day. In those kind of situations, yes. Where you have an obvious, cause and effect type of thing, where the records are very, very clear. You got hurt, you had emergency surgery the same day, there was no pre-existing anything. Maybe you can get away without the doctor's opinion. I don't like to risk it. Whenever I go to hearing, I like to have my doctor's opinions lined up, okay? Because I don't like to risk that. But that's not the way most workers' comp cases really are. I mean, there's some like that we get. Most of them are not really like that. Let's say, you didn't fall off a roof or anything like that. You fell on something slippery at work. Let's say you had a pre-existing ankle surgery. Let's say in this particular, let's just pick it out of the air, an example of ankle surgery. You had ankle surgery 3 years before this accident, okay? That now you hurt your ankle, same ankle again, okay? And the surgery that you had didn't take place right after the accident, took place maybe a year later. And in between, you had conservative treatment. They tried to, treat it, in a way, with pain medicine or with physical therapy, whatever, nothing worked. Eventually the doctor says, all right, we're going to have to go in and do surgery on your ankle. And maybe you even try to go back to work and that failed. And now they took you out again and they're going to do surgery, okay? So in that kind of case, which I think is probably more common, it's a little bit muddled. It's not 100% clear that this followed this and there's pre-existing issues also. In those kind of cases, what you need from the doctor, and you must put this into evidence in those kind of cases, and I think a lot of cases fall into this category, is an opinion letter from your doctor that sets forth all the relevant opinions, the first of which, and the most important of which, really means to be, in the doctor's opinion, with a reasonable degree of medical certainty or probability, more likely, or another way of saying it is more likely than not, the injuries and the treatment that this person went through, this injured worker went through, yes, is from this accident of, insert date. Before we go further, let me be clear, okay? This is only as far as an opinion letter, okay? The letter, putting a letter into evidence, that is only going to work in a Virginia workers' comp case. It will not work in North Carolina. Why? North Carolina requires that you actually take the deposition of the doctor. Those opinions won't come in through a letter. If you're going to go to a hearing in North Carolina, you must depose your doctor. It's typically done after the hearing, believe it or not. That's set up before the hearing, but they're done after the hearing within 60 days of the hearing date afterwards and at the defense's expense. In Virginia, the Workers' Comp Commission has very generously relieved you of the burden of having to spend all this extra time and, frankly, all this extra money on taking doctor's depositions. They will accept a properly worded and properly signed and properly dated opinion letter from the treating physician as evidence in your case of the doctor's opinions. The opinion letter from this doctor has got to have what I call the magic words in it. It doesn't have the right magic words in the right places, and it's not signed and dated by your treating physician, it is not going to be admissible in a Virginia workers' comp case. So that's important. Of course, you got to give proper notice to opposing counsel. There's definitely going to be a lawyer on the other side, a defense lawyer, and you need to give proper notice to that person. You can't just show up at the hearing with this opinion letter. What's going to happen then is that they're going to ask for a continuance. They haven't had time to look at it. They may want to do something to counter that. So you need to make sure you get this opinion letter well in advance of the hearing date and provide it to the other side, so assuming that it helps you, so that they get a chance to see it. I want to come back to this Virginia workers' comp hearing, though, exclusively, and tell you what you need to get your doctor's opinions into evidence in this opinion letter. And besides what I said before, namely that the doctor's opinions must be given to a reasonable degree of medical certainty or probability, or they all must be more likely than not, okay, to get to the standard of preponderance of the evidence that I told you about initially. What other magic words do you need to have your opinion letter accepted and used as evidence of your injury in a workers' comp case? So in Virginia, as I've spoken about in other videos, in order to be compensable, an accident must have caused what is known as a sudden mechanical change in your body. Okay? Basically what it comes down to is something must have changed anatomically in your body as a result of the accident. Sometimes that's just, you feel a pop in your back or something like that. But the doctor also needs to say it, okay? Sometimes it's enough for you to say it, but the commission likes to hear that from the doctor if they can. How does the doctor prove that? Usually they'll have an MRI or something. They say, yeah, something changed, or they see the trauma that happened. Something changed enough to where they can say that there was some kind of structural or mechanical change in your body as a result of the trauma you suffered at the time of the accident. They've got to be able to say that. If not, in other words, if you just had, I had back pain for years and my symptoms got worse. After I lifted this thing, my symptoms got worse. Well, did anything change? Nothing changed. That's not going to be enough. You've got to show this sudden mechanical change. That's the second set of magic words. So what the heck does that mean? So let's take an example of a few minutes ago. You had a prior ankle surgery 3 years ago in the same ankle that now needs surgery again. Looks like you re-injured it, slipping on some slippery stuff, right? On the floor where you work. A year after the accident, now you need the surgery again. You need it, you had it 3 years ago before the accident, now you need a surgery again. Can your doctor say that this, despite this prior injury that you had 3 years ago, something changed? There was a change that occurred on the date of the accident when you slipped, whatever happened to that ankle, and something moved or changed anatomically in your ankle. Assuming that it's something the doctor can point to on your MRI that's new, or just feels comfortable saying that, then I think you're good to go. Now, so far, we mentioned two phrases, two types of phrases that you need. First is the causation part. Let's go over this again. Reasonable degree of medical certainty or probability, or more likely than not, possibly is no good. Your case will fail if he says possibly. 2, in Virginia, again, you've got the more likely than not. the accident must also have caused a sudden mechanical change in your body, in the area where you got injured. What else is needed? Well, you need to prove that your ongoing treatment and disability, remember in the first example we mentioned, you're out of work completely. Well, is that due to the accident? Sounds like an obvious answer, but what you got to understand about this, nothing's obvious. You have the burden to prove. The commission's not going to assume anything, okay? They've got to see it in black and white with the right magic words, or you're not going to get it into evidence. So you need to prove that your ongoing treatment and disability, again, same standard as before, more likely than not, even if only partially, is related to your work accident of whatever date it was. Why do I say only partially? Because in Virginia, fortunately, we have a pretty liberal standard of causation. All you have to prove is the accident had something to do with your ongoing treatment and disability, even if only 1%, it caused it only 1%, okay? If that's, the rest of it was all pre-existing arthritis, but 1% of it is caused by, this fall or whatever it is that you had on the date of the accident. If the doctor can say that, feels comfortable saying that, you're good to go. The whole thing's compensable. Confused yet? Okay. I know it's a lot to take in. I'm just trying to lay out for you what no one else I think will probably do for you. Okay. So other than what we mentioned so far, is there anything else that's required? Remember I mentioned before something called medical necessity. Okay. We gave an example before where the doctor wants to put you in pain management. Now you're in pain management. You're taking certain medicines. Maybe they're doing injections. How do we know that that's necessary? Okay. Your doctor has to say it. And then that's simply that the treatment that you've been undergoing and that the doctor's recommended, plus and that any diagnostic studies they've ordered, any treatment they've recommended is medically necessary and designed to effect a cure for your work injuries of blah, blah, blah date. How do we get this opinion letter from your doctor? I can tell you what we do. We go over the 4 areas we just went through, and we ask in a very simple letter, is it true that, and we ask the question, those 4 things, okay? We leave 3 line spaces with a place for them to do a check mark, okay? Got 3 possibilities. Yes, no, can't say. That's it. So if they say yes to these all these 4 areas, you're golden. Your claim is good to go. If they say no, you might have a problem, okay? Or they say can't say, you're going to have a problem. If you ask the doctor to go write a report, maybe they'll get to it, maybe they're not. But and when you do it this way, all you got to do is do a check, look at the question and do a check mark. Yes, no, can't say. Much easier for a very busy doctor. Last thing we do, going over those 4 areas, we leave a little catch-all question. Any other comments you'd like to make on these issues? We'll leave a place for them to write any other clarifications they may have. Of course, you always have to have a place, preferably with the doctor's name written out at the end, for them to sign it and date it. Okay, very important to have a date and the doctor's signature. You don't have those 2 things, you have nothing. You got to get this letter, as I said, in your hands and filled out from your doctor well enough in advance of the hearing to give it to opposing counsel so they don't have an objection to make to get a continuance. Oh, we were surprised, we didn't know this was coming, etc. That's the 4 things you need. Again, one more time, the causation standard, more likely than not, or a reasonable degree of medical certainty and probability, number 1. Number 2, sudden mechanical change in the body part. Number 3, you have that the ongoing treatment and disability is related, at least partially, to the accident, the work accident. Number 4, finally, that you got to prove medical necessity and that the treatment that's been recommended, the treatment the doctor's been giving you, are all, at least partially, related to the accident date. That's the 4 things you got to have in order to really prove your claim on the medical side in court in Virginia in a workers' comp claim. Is this always going to work? Good question. Is this always going to work? And I'm sorry to say the answer is no. Why is it not always going to work? So let's take our example above, the ankle injury, where we said, surgery took place a year later. And let's say that in your first visit to the ER, the emergency room records fail to mention that you got hurt at work. And it only says you had surgery 3 years prior and you're having ankle pain. And then your second visit, maybe to a clinic or some other place, your records say, I don't know if you told them this, whatever, but your records say you actually injured your ankle at home. All right? Now, it's not until a month or so later that you get to orthopedic records that we see a proper history of you injuring it at work. Now, let's say the defense lawyer has also done what they often do in these cases, which is they've gotten you to go, and it's their right to do this, to an independent medical examination of their doctor, and their defense doctor looks over your MRI, looks over what it says in the records that I just mentioned, and says, in his opinion or her opinion, this accident has zero to do with any of your injuries. It's all pre-existing. It's all from arthritis and from 3 years ago. So can you still use you think with your doctor, the yes, no, can't say letter? And the answer is no. I'll let you in on a little secret. Deputy commissioners, the folks who decide your case in Virginia, hate seeing inconsistencies in the record. When they see a couple of records where it says, I got hurt at home, didn't say anything about a work accident, they don't like that. Okay, they're already against you. So what that means is if you're just going to do your yes, no, can't say, and your doctor doesn't mention anything about these inconsistencies, okay, it's not going to fly. And the doctor's going to say, your doctor didn't explain anything. Their doctor wrote some long report that mentions all these inconsistencies, shows how he came to a conclusion, and your doctor had better have an explanation, had looked at that report and read it and explain why he or she disagrees with it and why he or she is right that the accident contributed to your injury with a reasonable degree of medical certainty or probability. It is your burden of proof. And what is the deputy commissioner's job? All his or her job is to weigh the evidence. That means who has borne the preponderance of the evidence. And if they think the defense has better evidence than you, even though it's your treating doctor, and even though they're generally going to listen to your treating doctor over any independent medical examination, sometimes they don't. If your doctor doesn't explain themselves and the other guy does, that's it. You lost your case. I've given you some keys here. I've told you some things that other lawyers probably won't tell you. And so if you have a smaller claim, that maybe you don't want to get an attorney involved, it's a pretty, maybe you're back to work full time. Maybe you used some of your leave. Maybe, you used your health insurance to pay for all your bills. That's great. Good for you. You could probably handle this on your own, but you're still going to need those opinion letters. And I've laid it out, I think, how you can do that. But I say to folks who, where you really have a serious injury, you got huge bills hanging over your head, you're out of work completely, don't risk it. Please give us a call. Don't try this at home. Let us help you. One more caveat to you on this. Beware that sometimes this doesn't work. Sometimes doctors are they don't want to get involved. And they'll tell you beautiful things back in the examination room. Okay, oh yeah, this is obviously aggravated by your accident, at work, et cetera, et cetera. When it comes times to put pen to paper, they don't want to say anything. So I'm not saying there's no way to fix that, but it makes it much harder if they won't participate in your claim. I hope this presentation has been helpful for you. I know it's been a lot to take in. You can watch this, of course, the video, so you can watch it again and again and get what you need to from it. If you have any questions, if you or a loved one were injured severely at work, please don't hesitate to call us. Again, this is Joe Miller, workers' comp attorney, personal injury attorney in Virginia, North Carolina. Have a blessed day. Joe Miller out.